Hello again, I'm Michael Redden, and you're back again, and we're going to talk about another important estate planning topic. This one is your retirement accounts and things. You know, we're talking about the stuff in that IRA, that 401k, that simple, that SEP. Those are qualified monies for retirement. And it's a very important topic in estate planning because of two things. One, you know there's required minimum distributions. And when you reach a certain age, that money has to come out. And when it comes out, it's taxed, and it's usually taxed at your regular income rate. So it's one of the highest rates you can get. If it's not in that kind of account, it comes out and it's at capital gains usually. But most of the money that's in these accounts needs to stay in there, and you're required to take it out at some point. The other issue is protection of the assets. That qualified money in the retirement account, it has some special protections under the law, especially the 401k, because it's ERISA protected, right? And we've talked about that in other videos. But the thing with this is, once it passes to your heirs, if that heir is not your spouse, then the Supreme Court has said, hey, you know, probably we can't say that was held for retirement. And Congress intended to really just protect retirement from creditors. So once that goes over to these folks, it's fair game in bankruptcy, and it's probably fair game in most creditors for them just to come in and get that money. And you thought that the retirement account, when it was inherited, was protected. It's not. It should be placed into a special kind of trust to make it protected. It's called a standalone retirement trust. And that trust is one that you make for the heir. And it's a third-party settled trust. We've talked about those before, where the person who is the beneficiary wasn't the one who made it. So it's got a lot of creditor protection, especially in Minnesota. Can't even get to it for alimony or child support. And that helps them if there's any kind of creditor issues or divorce. Because remember, divorce is another thing. When you get divorced, we look at what you own in your retirement accounts and things. If they just had that IRA, then that's going to be fair game for one of those orders to split up all the retirement assets. But your heir doesn't own it if the trust owns it. So it's not a part of the divorce estate to begin with. And it has those extra protections from being considered for child support and alimony under Minnesota law. Then there's another thing. Remember those RMDs? When you start taking money out of it, that's when the taxes come and we start losing the real benefit of those things. If it stays inside that account, it just keeps growing and growing, tax deferred, it gets really big. Well, when you pass these on to heirs, you have to be careful about beneficiary designations, even if you don't put it in a trust, because you want that lifespan to be changed, okay? If you give it to a 13-year-old or a 22-year-old, you don't want the 22-year-old to have to take money out till they're in their 70s. Like everyone else. But if you just say, leave it to my children, leave it to my grandchildren, then we're going to look at the oldest person's age. If you say, give it to my kids, that's called a class beneficiary. And depending on how those things are looked at in your plan, if any other thing where you say, leave 25 to each kid, that, if you got 4 kids, that might be looked on as a class beneficiary, depending on how the custodian interprets that designation. And then we're going to use the lifespan of the oldest one. If you've got more than one kid and there's 10 or 12 years between them, then when that oldest child becomes 70 and a half, we have to start taking those distributions out. Everybody, even the one who's 12 years younger. And you can get a lot of inefficiency and things in that. These trusts always make sure that you only look at the beneficiary's lifespan because of how they're held. And so that's a very important thing to look at. And if you're going to leave over $200,000 or $300,000 potentially behind in one of these accounts, you really should think about having one of these trusts, because they're going to protect from creditors, and we're going to ensure that it's used for the appropriate purpose, so they don't just cash it out. It's going to also ensure that they can handle that money well, because you get to put the strings on what it can be spent for, and it's going to maximize that stretch so that they get the benefit of the compounding and the growth just like you did. You can make it go even longer. So keep that in mind.